Well, we're now joined via video link by Melusi Xulu, legal analyst and managing director at Donda Attorneys Incorporated. Melusi, a very good afternoon to you. Thank you so much for joining us this afternoon. So for the better part of this week, the Western Cape High Court is going to be hearing this matter. Essentially, you have these separate challenges to the Act being consolidated into one hearing. In the main, are applications by the DA, AfriForum, etc. We know that the DA will make strong arguments in the Western Cape High Court that the Expropriation Act itself was approved unlawfully by Parliament. Just walk us then through what are the legal questions before the Western Cape High Court and the areas of the Act that are currently under scrutiny.
First of all, good afternoon to you, Nancy, and to the viewers at home. Thank you for having me. Well, one of the sections that are raised as an issue, especially, I'll start with the DA. It is section, I believe it's section 19, that talks about, the time limit you have when you're making an opposition to expropriation. For example, the section says, if you don't agree with the government on expropriation, then the time limit will start from there. But if you look at section 7, subsection 6, paragraph A, it talks about the fact that the notice starts when you get a notice from the government. So those are the two things that are inconsistent. Sorry, but what the president has said is that he partially agrees with the issue that there is a contradiction. But he has just suggested that an interpretation is made in a corrective way rather than deeming it to be invalid or unconstitutional. But the other issue that they've raised is the one that you've raised, that how the parliament was not passed properly with the National Council of Provinces. So that's another issue that they have. But I think when you also look at what AfriForum has said, I think what AfriForum has said is interesting. If you go to section 12, subsection 3, before you go to the subsections on paragraph A to D, it says the compensation can be nil, but it's not limited to what is stated, meaning it's open-ended and it's giving the government more power to determine how nil compensation can happen. So I think those are one of the issues that they are raising. But what is important is the Act seeks to readdress the imbalances of the past and how land was taken away from, especially from Black people. But the problem is, if you go to section 25 of the Constitution, it talks about land not being expropriated in an arbitrary manner. So that is the challenge. I think that is the main question, to say, is the Act in its entirety, whether it's in section 19 or section 7 or section 12 or any other section, is the Act not taking land away from the people who own the land in an arbitrary manner, which is in the Constitution. So I'm just stating what is in the Constitution. It's not necessarily a personal opinion.
Yeah, I want us to take a small step back. I mean, we've heard the phrase expropriation without compensation many a times. From a legal perspective, and given what you've just been saying, is that an accurate description of what the Expropriation Act allows in its entirety? Or is the more nuanced than that?
Yeah. I think the main subsection or section that is important is section 12, subsection 3. What it says is land may be compensated and they may be nil compensation under the following reasons. Paragraph A says, if the owner is not using the land or is not developing the land, but only is keeping it for maybe when the market has increased, he will then sell it, then that land can be compensated. It also says, if the land is owned by the state, but not for its main purpose, for example, if it's a certain department, but the land is owning is not being used for any purpose that lies with the department, then that land can be compensated. Yeah. Also, thirdly, it says the land can be compensated if the owner has abandoned the land. So if the owner has abandoned the land and they've investigated that the owner is not using that land can be taken, but then there will be nil compensation. Then lastly, before I conclude, the Act also says the land can be compensated if, for example, the development that has been done by the state on it is equal to its market value. Say, for example, the development that has been made by the state is 500,000, but the market value is 450,000. Then that land can be compensated without any compensation or nil compensation. So in the main, it's not necessarily expropriation without compensation per se. They are looking at it to say for a public interest or for the interest of the public, if those four situations or more exist, then there can be land that can be expropriated and there will be nil compensation. But if there are objections, there's also, I believe that is in section 19 that talks about mediation. There's also a legal way to deal with that and to be able to challenge what the state is saying.
Yeah. Very quickly, Melusi, as we wrap our conversation, if the court finds a procedural defect, does that void the entire act or only require Parliament to rerun the vote based on, of course, what the DA has been saying about the NCOP process?
Yeah, I think if the court finds the act, because remember the DA wants, I believe it's the DA that wants the act to be deemed unconstitutional and to be invalid. So it will depend which side the court agrees with. But if the court says certain sections are invalid, then the Parliament may be then ordered to amend those sections depending on what the court says. So we'll look at after this week and see what the court has determined once the judgment is ready.
Yeah, thank you so much, Melusi, for your time. And of course, AfriForum says it will go to the Con Court.